Good evening
Good
to
evening.
all our enthusiastic, honorable, very punctual, and very honest and reciprocal honorable guest, Dr. Ram Sharnagat Thakur Saab. He's ex-secretary of Pharmacy Council of India. He is to deliver a lecture on drug control and etc. And again, I invite another honorable, very eminent, popular, acclaimed speaker and counselor in legal subject, Advocate Mukul Shastri, who was felicitated yesterday by Forbes. Indeed, am I right, Mukul Shastri ji?
Thank you, ma'am. Yes. So,
Very
Folk
warm.
India yesterday awarded me the
And
top 50 women accountants.
our another third speaker is Sujala from Bhimrao Ambedkar University, Jaipur. She's also an advocate as well as an academician. And the other two guests are the chief guest, Dilip Nandekoelyar, and another one is honorable guest is Dwarka Prasad Uniyal. So they would be joining very late at 7 or 7:15. So meanwhile, I'll read the report. First of all, the host, Bhupal Nobles University Udaipur, Rajasthan, India. It's a academic unit of Vidya Pracharni Sabha Trust in the AGs of Bhupal Noble Sansthan, celebrating its 100 years of its foundation and establishment. So it's
Oh,
a centenary year of celebration, and they have um, in that sequence of celebrations and organized an online symposium in law and legal studies from 25th March to 31st March 2022 from 6 p.m. onwards on the theme concerning private law, common law, and civil law. In brief, we can say law of tort. And the title of the symposium is The Changing Concept of Liability and Its Variables. The program of Symposium of 7 days has been in association with Gaius Institute. Gaius was a Roman jurist existing in the common era of 110 to 180 AD, and he was famous for his canonical writings, especially institutes. So, in that context, the founder members of International Institute for Advanced Legal Sciences, Buenos Aires, Argentina, has associated with us, and the program is co-hosted by Professor Salvatore Tolone Azzariti. He is also the panelist. In his mentorship, we are holding this event. The program professor is of civil law, and he's from University of Oxford and Universidad de Buenos Aires, Argentina. The organizers of the event are the Honorable President, Professor Naresh Bahadur Singh, Honorable Registrar Shri Parbat Singh Rathore, Dean Dr. Ashutosh Pitalia from Faculty of Law, Bhupal Nobles University, Dr. Kamal Singh Rathore, Public Relations Officer, Faculty of Pharmacy, Ms. Kiran Chauhan, Assistant Professor, Faculty of Law, the chief coordinator of the event, I myself, and convener and the concept note writer, Dr. Jayashree Singh, Associate Professor, English Department, Adjunct Faculty of Law, Bhupal Nobles University Udaipur. The chair of all sessions is our Honorable Professor Sharath Srivastav, the formerly Dean of Law, Mohanlal Sukhadia University, as well as he was formerly Dean and Chair of University College of Social Science and Humanities. The program was supported by many other resource persons. For example, Miss Pushpalata. She is a faculty in Bhopal Nobles University in Faculty of Law. Then Kusum Lata, Dr. Shikha Nagori, Krishna Shaktawat. Then Dr. Abhay Jaroli, formerly Dean of uh, Faculty of Commerce and Management, Dr. Girish Gupta, Chartered Accountant Jaipur, Dr. Satish Nagar, Advocate Gujarat, Dr. Anil Kaushik, uh, School of Law, Bikaner; Dr. Vartika Arora, Principal from Rajasthan School of Law, Women, Jaipur; Dr. Manoj Meena, Faculty of Law, University of Rajasthan, Jaipur; Dr. Rashri Potlia, College of Law, Mohanlal Sukhar University, Udaipur; Dr. Professor Anand Paliwal, Dean Faculty of Law, Mohanlal Sukhar University, Udaipur; Dr. Shilpa Seth, Dr. Priya Darshi Nagda, Dr. Kalpesh Nikawat, Miss Kripa Jain, Miss Bhumika Chaubisa. They are all from Mohanlal Sukhar University, Udaipur. They have associated with us in giving lot of resource persons as well as counseling to carry on with this event. So our first day session was marked by the presence of Honorable Keynote Speaker Shri Mukesh Bansal, Company Secretary, fellow member of the Institute of Company Secretaries of India since 1982. He spoke on role of regulators, young investors and professionals to learn global money week 1922 special. The second speaker of the first day session was from the host institution, Ms. Karan Chauhan. She spoke about environmental law and liability. And on the very first day, Professor Salvatore, welcome, good evening, sorry, good morning to you.
Good morning.
He's
Good
here, our
evening.
co-host and panelist.
Good evening to you.
Good evening, sir. Thank you for joining us and blessing us and to carry forward with this event the last day. I'm just reporting the 7 day the speakers sessions in brief, so that we can recapitulate what happened in the last 6 days. So, Professor Salvatore, in the first session of the day, spoke on fault liability in the law of tort. Then, the second day of the session had the acclaimed National Law School Jaipur alum, Dr. Rajkumar, Associate Professor, Department of Law, University of Jammu. He discussed about criminal liability in competition law. Then we had Honorable Girish Gupta, Chartered Accountant, who discussed about liability under Motor Vehicle Act. And then Ms. Chaubisa, research scholar from Sukharia University and alumni of Bhupal Nobles University. She talked about breach of duty with reference to Motor Vehicle Act. And then Professor Salvatore, he discussed about the on the second day of the symposium, elements and forms of liability in private law. The third day of the session had resource persons Mr. Shiv Singh Chauhan, former district judge in Sessions Court, Udaipur. He threw light on Land Revenue Act. Then Dr. Praful Bala Honta, consultant gynecologist from Dungarpur Medical College, referred in her lecture about duties of medical practitioners in medical colleges. Then we had a MLSU scholar, the Kripa Jain, she talked about liability under contract. Then the session was chaired by Dr. Ashutosh Pithalia, Dean of Law, who spoke about liability under Motor Vehicle Act. On the very third day, Professor Salvatore, the co-host, addressed upon recovery of damages, punitive damages, and remoteness as according to German law of civil code. The fourth day of the symposium had the Honorable Dr. Pranjal Kumar Fukan from Assam. He is a chairperson of the Northeast Chamber of Commerce, founder member of Common Minds. He discussed about liability under contract. Then we had Honorable Dr. Alok Yadav, Associate Professor of Law from University of Lucknow. He delivered lecture upon tortious liability of state. On the very fourth day, the same day, the Honorable Dr. Mahavi Chaplot, Chartered Accountant from Udaipur, an owner of Chaplot Associates, an expert in private equity, discussed about Indian budget 2022 and its critical impact. The session was chaired by Professor Chandrakash Gupta, Dean Faculty of Law, Apex University, Jaipur, who gave valuable inputs, remarks, and critical view towards the theme of the symposium. And Professor Salvatore, he spoke about the breach of duty and breach of contract in terms of civil law. The fifth day, The fifth day, I think it was 29th March of the symposium, it was honored by the respected Mr. R.N. Mathur Sahab, Senior Advocate, High Court, Rajasthan. With his 40 years experience in the legal services, he talked about changing concept of the liability and its variables. On the same very day, Dr. Rakesh Priyani from Vadodara, Gujarat, and is deputed in traffic court, judicial magistrate. He spoke about the concept of negligence with reference to accidental cases. He is also an alum from Mohanlal Sukhadia University, Udaipur. The Advocate, Supreme Court of India, Assistant Professor of Legal Studies at OP Jindal, Pragya Parijat Singh, she dealt with the concept of liability in terms of Code of Civil Procedure and substantial provisions. Then the session was chaired by Professor Dr. Kalaminath, Dean in the Faculty of Law, Janardhan Rai, Nagar, Rajasthan Vidyapeeth University. She discussed about liability in a general way. And then Professor Salvatore on the fifth day, his lecture was on transcendent nexus of causality and civil equivalability in medical practices. On the sixth day of symposium, we had lectures of senior advocate of Rajasthan High Court, Rajiv Surana. He spoke on Land Revenue Property Act, and the Honourable Speaker Advocate Prema Priyadarshini, who is the mediator arbitrator in Delhi High Court, New Delhi, discussed about liability in terms of employee insurance and compensation. Professor Salvatore on 30th March, the sixth day of symposium, discussed about consumer protection and liability in perspective of European Union laws of consumers, conforming and non-conforming goods, and termination of the contract. The session was chaired by Professor Sharad Srivastav. He's also the external expert board of English Studies, Bhupal Nobles University, as well as a professor of Mohanlal Sukhadia University. He contributed with his special inputs in understanding the contemporary changes, in understanding the concept of liability as specific sense. The last day, not today's day, the final symposium day, has the privilege of august speakers in the field of law and legal studies, management, and human resource. So, our chief guest of today is Dr. Dilip Nandekoelyar, Director, Industry Research, Head of the Department Marketing at Universal Business School, Co-Chancellor Adjunct of Commonwealth University London, United Kingdoms. He's also alumni of Ancient Institute of Management, Manila, Philippines. Our next honorable bona fide citizen of Udaipur, Dr. Dwarka Prasad Uniyal. He is also one of the student of my father-in-law, Professor Arya Kumar Singh, the founder of Faculty of Management Studies. So he would be giving us here the privilege to honor him. And he is the founding dean, School of Economics and Business, Rashtriya Vidalaya University, Bangalore. The third honorable speaker of today is Dr. Mukul Shastri, who was awarded by Forbes for his being an enterprising legal counselor, vice president, and head of Legal Welspun Enterprises Ltd. He has to his credit the number of academic qualifications, Master of Business Administration from IMA, Philosophy of Doctorate, then Bachelor of Law, Masters of Law, and last C.A.I.I.B. I could not decode this acronym. Could you just speak in? What does it stand for, C.A.I.I.B.?
This is basically a chartered associates for Indian Institute of Banking. So for the banking and finance field, those who are the bankers or those in that field, they generally do this course. So there's basically a certified associate or chartered associate for the Indian Institute of Banking. It's a CA for banking, basically.
Right. Thank you, sir. Thank you.
Thank you.
And our another speaker of today, we had actually three sessions who would be delivering in real sense the lectures. And so the another fourth speaker is Advocate Sujala Dean and Head, Faculty of Law, University of Rajasthan, Dean Dr. B.R.Ambedkar, Law University, Jaipur. And our fifth honorable speaker is uh, R.S.Thakur Sahab, Ex.Secretary, Pharmacy, Council of India, and the co-host of the symposium is Professor Salvatore Tolone Azzariti. Here we welcome Dr. Nandekoelyar. Also, he is our chief guest. Professor, thank you for joining in time, but you have to bear free lectures. Then only you can be there for your presence, gracious presence and blessings to
Not
enlighten
a
us.
problem at all. Not a problem
Thank
at
you.
all.
Thank you, sir. So, first of all, I would like to invite our first speaker of the day, Advocate Mukul Shastri, to continue with his lecture. And then second lecture would be deliberated by Dr. Ram Sharnagat Thakur Sahab. And third lecture would be contributed by Sujala Thanvi from Jaipur. So, I leave the dais and as well as the platform for Mukul Shastri.
Thank you. Thank you so much for having me and for this kind introduction. Good evening to every single person present here. It's indeed a pleasure to present my thoughts before such an august audience. Thank you so much for having me. Now, I was just going through, and I'll try to keep myself brief as near possible, in which I can just convey my thoughts also and not taking much of the time of this august audience. Now, I was going through the wonderful presentation made by Dr. Jayashree, whereby she was quoting that what all subjects have been deliberated and discussed in this wonderful symposium. And from motor vehicles to tortious liability to civil law to common law principles, contracts, a host of things have been deliberated, which is very, very, very interesting and thoughtful. And in fact, this topic itself, the basic what do you call it, the framework is also very interesting, whereby it says that the discussion on the symposium is on the changing concepts of liability. Now, that is something which is very, very thoughtful, because see, what was the liability, say, 50 years back, the concepts or the legal conundrums or dogmas may not be the same today. There's lots of water that has changed. A lot of things have changed in past so many years. Though the fundamentals of law might have remained the same, but then the conundrums, how they interpret things, have completely changed. And this is where I will be discussing a little bit of all these things and see how the liabilities, the concepts have changed over the years. Now, first of all, a very interesting piece that I've seen here while Dr. Jayashree was going through what all has been deliberated is that there's a discussion on tort, there's a discussion on contract, there's slight discussion even on competition law, and there's a discussion on consumer protection. So my PhD is in competition law. Way back in 2006, I did my PhD. At the time, this law was a very new law and has fascinated me then, and it still fascinates me even today. It's a very interesting piece of legislation. And it is interesting to note that you have had a discussion on this topic in your symposium. Now, before we deliberate into the nitty-gritties of these legal concepts, one thing which I really would like to discuss is that, okay, when a thing is taught, when is it a contractual violation, when it is under consumer protection, and when it is within the subject matter of competition law. Say, for example, any unfair trade practice, if you have an anti-competitive agreement or any other unfair trade practice, if you see Section 3 of Competition Act 2002, you will see that unfair trade practice or maybe anti-competitive agreement should fall in Section 3 of Competition Act. Then and if you see the Consumer Protection Act also, whether it was 1986 or whether it is now 2019, you will see the unfair trade practice is covered there also. Now, when a person should take recourse under which law or what law will apply to who is an interesting dilemma at times which is faced by the law courts and by the legal practitioners. Likewise, there's the case of Dono versus Stevenson, a very celebrated case, old case. Whosoever has done tort, studied tort, whosoever has done law knows about that case. So that Dono versus Stevenson, that is a contractual liability, or was it only a tortious liability? A person is purchasing something to consume from a shopkeeper. Is it a contract between these two parties? And if this thing is consumed by this person, is he a consumer? So shall he go and file his remedies under consumer protection, or shall he file his remedies under tortious liability? Is a very interesting piece to discuss. Though Dono versus Stevenson case is always treated as a case of law of torts, because they feel that these are civil wrongs which are not contractual. But then again, this is also very fascinating. Say, because contract need not only be any written agreement between two parties. Any transaction which covers the ingredients of the Indian Contract Act covers within the definition of a contract. So if it is an agreement between two parties which has any consideration, which is not having any object which is unlawful, and which otherwise satisfies the ingredients of contract, is a contract. So any lawful enforceable agreement is a contract. So if I go to a shopkeeper, purchase something, and if that product is faulty, whether I consume or some of my friends consume, how is that a subject matter of tort when it is a subject matter of contract? So this is again a very subtle, simple, but a very complicated piece, that where, under which law your remedy lies. If we go back in this case, when this Dono Stevenson case happened, or way back, say 50, 60 years back, because the courts are not the courts only of justice, but they're the courts of equity, justice, and good conscience. Therefore, all this judge-made law, this tortious liability, all these things were developed by the variety of pronouncements by the court of law. And in their own wisdom, they thought that, see, there are certain aspects, there are certain things which cannot be classified as contractual liabilities. There may be some overlap. There may be something whereby we can draw a kind of a Venn diagram and say that there's an overlap. But then, what is the basic feature or the basic difference between what will fall where? So far as tort and contract is concerned, is that any action whereby the intention of entering into a legal relationship for a contractual sense is there, then only it will fall within the definition of contract, within the four corners of contract. And if that somehow is missing in the transaction, then it will fall within the category of civil wrong, and it is a tortious liability if something goes wrong. For example, if I take ticket and go and watch a match of IPL in a stadium and something hits me, then I can get the protection of voluntary non-fit injuria under tort, because that was a tortious liability, because that transaction was never intended to be a transaction which creates any legal rights. The transaction of watching a particular match and a ball hitting me. So that transaction was not a transaction which always have any intention of creating legal relationship between a person who's watching the match and a person who's playing in the ground. And therefore, it may result in a tortious liability. It may result in those exceptions also. But on the contrary, if I take a ticket and go inside, and there's a problem in the seating, if there's a problem otherwise in my entry, or if there's any other problem, they've given me an inferior place to sit than what I deserve based on the ticket I have purchased, that is a contractual dispute which will go for the contractual liability, because there was an intention to create a legal liability based on this transaction. So this is a contract. Why? Because there was an intention whereby I had the intent of purchasing this ticket and I wanted certain rights to be given to me based on the consideration I have paid. So that is the distinction there lies. Now, if we extrapolate this distinction between this tortious and contractual claim to a newer regime, that suppose if there's an unfair trade practice, then whether that will fall under a Consumer Protection Act or whether it shall fall within the four walls of competition law. Now, before even deliberating into that when there is something wrong, suppose if the two parties, they do a cartel, there's an anti-competitive agreement whereby they are going to rig price. Is it going to ultimately impact the consumer, or is it not good for the competition? And competition is what? Is it only or not only for the consumer per se? When we say there should be good competition market, ultimately the end user, the beneficiary is always the consumer. So can't we say that the entire thing is within the framework of consumer protection? And then what will go under what law? What should be the domain of competition commission, and what should be the domain of the dispute redressal forums under the consumer protection is again something which we have to deliberate to understand the nuances. Now, before getting into this, if you see, given that the concept is of changing liability or a changing concept of liability, see, way back, because the Indian economy till 1990 was a closed economy, it was basically into a socialist mode of economy, a command economy in a liberal sense. If you see, at that time, we had an act called MRTP, Monopolies and Restrictive Trade Practices Act. And that act primarily was just to focus that there shall be no monopolies that has to be created, because it was presumed that monopolies per se are bad. Now, the entire intent was that if your action are trending you to be or making you a monopolistic player in a market, then those activities of yours shall always be they should not be taken in the right spirit, and they should be under scrutiny. And if you thereby violate any of those rules specified in that act or rules made thereunder, then you are liable for the actions under that act. Which, after 1991 was thought, if you will have such a strong regime whereby every single thing is to be controlled, then maybe it is not good for the for the market, and market liberalized. And in 1991, the government thought that let's move away from the license raj, let there be a proper competition market, let the competition flow. And that's how, way back in 2002, the government thought that now, since we have open and free competition, there's a time whereby we have a regulator which is going to regulate this free competition based on the principles and the learning that they had from EU, from the US, way back in Sherman Act and way back in EU's competition laws and those doctrines. So they thought that now in India, Indian market is pretty open. So there should be a regulator based on those well-established principles in EU and US should come and regulate the market here. So therefore, the entire focus shifted from ending monopolies to a regulator which promote competition. So the entire mindset changed. Now, this competition regulator, which is given the duty of ensuring that there should be a fair and free competition, and the entire act was framed, which has primarily three pillars. Now, what this regulator has to do, this regulator has to see three primary things. One is there shall be no anti-competitive agreements, which is Section 3 of Competition Act, and then there are certain rules that what can be called as anti-competitive agreements. The second was abuse of dominant position. Here again the concept changed. You can have dominant position. Per se, dominant position is not perceived wrong. Only thing is you should not abuse your dominant position to stifle the competition. That is what again Section 4 of Competition Act talks about. So our focus was now not only of preventing a person from creating a dominant position, but from ensuring that this person is not abusing his dominant position. If you buy your own organic growth, you thereby becomes a very dominant player in the market. That was most welcome by the competition rules and framework. And the third thing is regarding the merger and the combination, the third pillar, whereby they say that all these combinations, all these mergers, all these acquisitions, because all these acquisitions ultimately ensure that there's only one player in the market, they also ensure that there are lesser efficacy in the market. And therefore, all these mergers, all these combinations should also, of a certain size, should also have a pre-clearance from competition angle. And therefore should always go to the regulator first. Regulator should see that whether this merger is creating efficiencies or this merger is not that good for competition per se, and in the relevant product market, in the relevant geographical market, this merger is going to cause more harm than what efficiencies it brings on table for the end users, for the consumers. Then it should not allow those kind of combinations. So these are the three primary pillars under which the Competition Commission was allowed to play its role. But see, all these three things, whether it is anti-competitive agreements, whether it is abuse of dominant position, or whether it is a combination, these three players, what are the tenets, what are the principles that this Competition Commission has to look into? What they will think about when they are considering whether a particular agreement is anti-competitive or not, or whether a horizontal agreement is bad or not, whether a vertical agreement is good or not. So obviously there are certain principles under competition law, there are certain principles enshrined in the various sections of Competition Act. But then again, ultimately, if you see the crux of all these principles is the end user, is the consumer per se, the person who's going to consume these things from these industries. It is that person's importance, that person's interest are paramount. That person should not suffer. So by cartelization, what are you doing? You are increasing cost for an individual, for the end users. By abuse of dominant position, what are you doing? You are trying to stifle competition, and ultimately it is the consumer, the end user, which is going to suffer. And likewise by combinations, the moment everything becomes monopolistic in the hands of few, who is going to suffer? The consumer is going to suffer. So can we say that primarily the aim of competition law is obviously to maintain the economic balance of the country, but ultimately it is for the benefit of the consumers only. So competition law is nothing but just an extended arm of consumer protection. Can we say such a thing? Is that thing tenable? Which looks like apparently prima facie, because the ultimately interest is there. And there's an overlap also. If you see the Consumer Protection Act, whether of 86 or whether the latest amendment, ultimately every single thing, I'm just cutting it short, not going to integrity is there, but ultimately it also has an element of unfair trade practice and restrictive trade practices. So those elements also indicate that the the any player which is doing or which is entering into any unfair trade practice and a cartelization or abusing your own dominant position is also somehow it gives a semblance of unfair trade practice. So therefore, this means that so the remedy lies to a consumer under both acts. Then if I as a consumer suffer, then I can approach the consumer protection dispute resolution forums and all the consumer what you call entities. I can go to these forums and thereby claim my remedies, even if those remedies are ones which are crystallized or covered under competition law. Can I do so? Can I go to a consumer protection dispute forum and say that there is an anti-competitive agreement between parties and thereby I, the consumer, is suffering and therefore should give me remedy? Can I take this kind of a stand? And if I cannot take the stand, then what is preventing me? Am I not the consumer? Am I not the consumer of those articles and those things? Well, ultimately, I'm going to consume those. So suppose there's a cement cartel. There are a lot of cases on cement cartel in competition law. I am the ultimate consumer who's going to make my house, and therefore I will require that cement. And if the rates go up, it is me who suffers. It is me who's suffering because of that unfair trade practice. And can I go and take my remedies and the Consumer Protection Act to district forum or to a national commission or state commission based on the valuation, etc.? Can I go to those forums and claim that my remedies lie there and quote the violations which are streamlined under Competition Act sections and rules? And if I cannot do so, then what is it that doesn't allow me to claim those liabilities here? As I said, so it's very similar to talk about that when we are talking about tort and contract, that when I'm consuming something, if I'm taking something like example was Morgan Stevens, if I take something from a shopkeeper and I go and consume that, and there's a negligence of the shopkeeper by giving me a poor product. So is that a violation under tort law, under tortious claim? Is it a civil wrong which can be claimed as a tort? Or is it a civil wrong, or is it wrong to a consumer whereby I go as a consumer and claim my remedies? So in tort and consumer protection, as I said, the differentiating line was whether there was an intention to get into a legal relationship, and that is where we'll see from that lens and that prism and see where you fall into. And if there was no intention to enter into a legal relationship, I can always go under tort and not under contract. Because if I'm driving something and thereby cause harm to someone, my conduct may be negligent. I may have committed a civil wrong, but I have never done a violation which can be said to be a breach of contract, because there was not a contractual liability to me to not be negligent. Unless there's a specific contract which I have signed with someone which says that you cannot be negligent, and if I then be negligent, then the breach of contract, because then there was a legal relationship for me to fall there. So now extrapolating that and using the same analogy to hear that when you can be said to be approaching the consumer forums and when you can be said to approaching the competition law, again it is primarily the intention or the what you call the scope and gamut of things. So consumer protection remedy, we can say, is a remedy whereby an action of a party causes harm to a set of consumers, to a particular person. For example, like I gave example of cement cartel, I am making my house, and therefore the cement price goes up. It is going to cause harm to me, and therefore, if I suffer thereby, I should approach there. But to approach there, I have to prove that I'm a consumer, isn't it? So I have to purchase the thing, and I have to say that this particular thing is faulty, it is unfair trade practice because there is cartelization, which may not be covering under the definitions which are there in the consumer protection. Because in consumer protection, you have to be a consumer and prove your merit in case under that particular act and those definitions. On the contrary, under competition law, a particular action which is obviously going to impact the end consumers ultimately, but which is going to have a far more reaching approach. If we allow a cement cartel, it is not only impacting the price of cement at one place, it's going to disturb the entire economic system. It's going to create an entire scheme of things, which for the economy as a whole, for that relevant product and relevant geographical market, is going to create inefficiencies in the market. So this legislation is primarily based on an economic-based justification. So under economics, if the entire action is such which is not going to impact, obviously it will impact the ultimate consumer to a certain extent, but it has to be beyond that also. So it does impact the ultimate consumer, but beyond that, it is disturbing the entire economic spectrum. The violation is such, then that violation will be a part of which should be covered under the Competition Act, because the entire jurisprudence of competition law is based on that. And therefore, any actions which maybe till 2002 would have been easily passed on as unfair trade practices or restrictive trade practices, may now today may not be that simple to pass into those definitions, but to be covered under the competition regime because of a new piece of legislation and because of a new piece of jurisprudence. Therefore, any violation now which is of a wider spectrum, any action, any horizontal agreement or a vertical agreement or a combination or an abuse of dominant position, whereby it is not going to impact only a particular set of people, but which has its repercussion beyond certain things, obviously within the relevant product and relevant general market, but the impact is widespread. So they are subject matter of competition law. They are subject matter of those legislations, and those regulators have the power. Now, before I just conclude here, again, an offshoot from this only. Then what about sector regulators? Because there's a possibility that there is a bank which is involved under competition law violation. There's a bank which can enter into an unfair trade practice or basically into an anti-competitive agreement. What will happen then? Will that be covered or regulated by RBI, or it should be regulated by the Competition Commission? What about a listed entity? If a listed entity is doing some wrong, will it be regulated by SEBI or will it be regulated by Competition Commission? Again, same thing. Till the competition regulation was not there, till this regulator was not there, the liabilities or the actions of sector regulators were there, but then the sector regulators were regulating them only from their own perspective. So RBI was regulating banks only from banking perspective, from BR Act violations or maybe FEMA or maybe other, if it was an NBFC, from NBFC regulations. So from that angle, only RBI was evaluating, finding out what faults are there from that perspective. Likewise, if you are a consumer and you find something wrong is there, any unfair practice is there, before competition law, even for those actions which today may be classified under competition act definitions, you are still going to the consumer protection and finding recourse there if you are individually wronged. But the moment a competition regulator is there, which is specialized in doing a particular set of activity and whose jurisprudence is for a particular set for competition angle. Now, what is the competition angle jurisprudence is again to a somewhat extent defined and established by the conduct of the regulator in past 20 years. So for those angles, for those competition law principles, so if a bank violates the competition law principle, if it is entered into an anti-competitive agreement, it is going for a merger, demerger. If it is going for any abuse of dominant, the bank is regulated by both the entities, from RBI, from banking perspective, banking regulation perspective, and from competition commission, from competition perspective. And that is where at times there's a lot of overlap and there's a lot of gray area. So under banking regulation, RBI has a right to tell a bank to go for a merger, which is a compulsory merger. Likewise, in banking regulation, RBI has the power to give a voluntary merger also. If two banks want to merge, they can come to RBI for a voluntary merger scheme, and RBI can allow it. And it is and banks are companies also, so they may have to go to NCLT, but then that is more procedural. But can a competition law say that no, RBI might have asked for a mandatory merger because from banking perspective, but given the competition perspective, it may create, this combination may create some kind of inefficiency in the market, and therefore I stop you as a competition regulator from not merging. So if it is a voluntary merger, still it is okay because two banks have to take approval of both the regulators. But what if it's a mandatory merger? What if RBI directs? Then what will happen? Then there's a clash of regulators, and who is going to settle those things? In those cases, obviously, it will ultimately go and test it within the touchstone of the principles of law before a court of law. But then the principle again remains the same, that whatever that activity is, like in our example, the merger activity. Now, RBI can only permit it from RBI's perspective, from the banking regulation perspective. It may be creating a lot of sense from a banking perspective. But if the Competition Commission can justify that, no, this is not creating enough efficiencies for the end users or for the economy as a whole, but causing more inefficiencies, and it is justifiable in doing so, then it can even stall that kind of a merger. So therefore, and likewise for a voluntary merger, Competition Commission can give a permission for merger, but then again RBI can halt it. So therefore, this also is a very, very, very gray area, and that also can create changes in how you approach which forum and which entity for certain things. But there are a lot of gray areas also here. Everything other thing is not very crystal clear. But ultimately, the basic principle or the fundamental is this only, that whatever sector regulators are, their rules is specific to their sector, and they can only give permission from that perspective. Competition Commission, on the contrary, will give permission from competition law perspective. So very similar to what when you can approach as a consumer to a consumer forum when you are wronged as a consumer individually. But when again it is a matter of economic efficiencies, it is the Competition Commission which is the better judge of things. So this is basically my some humble submissions before this August audience, my piece of brain. Again, I thank everybody for having me here. It's a wonderful, wonderful session and symposium. I wish Bhupal Nobles University all the success in coming times. And with this, I rest. Thank you so much for having me.
Yeah. Note.
I guess Ms. Jayashree is not there.
She has left just now.
Okay, maybe some technical issues. May I request the second speaker to take it up, or we shall wait?
Should we proceed, or Madam has left, it seems? Okay.
Let me just ping her on WhatsApp.
ये कैसे कनेक्ट होगा? एक सेकंड इसको कर देता हूँ। यहाँ से तो क्या है? अनम्यूट करके देखिए। Nobody is coordinating, it seems. Somebody has to coordinate, na?
That's right. I guess Dr. Jayashree was supposed to coordinate.
She's not there, it seems.
Yeah, I do not know. I just messaged her. So WhatsApp, is there some net issue or is there some net issue or something at her end? And she has not yet responded, but hopefully she may respond in some time. Otherwise, yeah. Otherwise, if he doesn't respond in 1 or 2 minutes, we can continue the second speaker.
No, but I tried. But this PowerPoint is not connecting. You are not allowed to share your screen. That message is coming.
But she may have to permit the specific things. Okay.
Yeah.
So let me just message her. Let me just message her that nobody can then be in a position to present properly. Just give me a second.
problem is there? तो यहाँ खुला हुआ है और वहाँ आता नहीं.
I guess Dr. Jayashree joined.
इनका मूक है.
Ma'am, you are not audible.
हाँ,
You on mute. You on mute, ma'am.
Please unmute. हाँ.
Dr. Sanjula, do you want to continue first, or shall I request Ram Sharan Thakur Sahab to just speak after Dr. Sanjula?
As you wish. No problem.
Okay, Dr. Sanjula, you can continue with your.
इसको कैसे?
Okay, thank you, ma'am. Thank you very much.
हाँ, ये तो अभी नहीं होगा. इसको बंद करना.
Today's my topic is changing concept of criminal liabilities of corporate and their officers. That is basically upon the corporate criminal liability. As we all know that a perception that only humans can commit a crime is an invalid concept. So today I'll try to find out whether a corporate can be held liable or not for the offenses what they have been committed. At large, large-scale enterprises are all over the world, and these corporations are held to be the characterizing powers over the globe in pretty much every part of our life. Corporate has turned out to be dangerous criminals. As a principle, people only commit the offense, and the exemption to this standard is that corporate bodies can be held accountable for the corporate violation. The subject of research here is that whether a corporate body is fit for pretending a wrongdoing, and on the off chance that truly at that point, how a company can be held criminally liable by the law. The prior view was that an organization ought to be accountable for a crime, and the criminal blame required a goal and an entrepreneurship, and enterprises not have a should they don't have a physical structure for that. Additionally, a company had no body of its own which could be detained, and the court are probably going to impose the risk on the officer in control or chiefs or different persons acting within the extent of business. From the years together, the doubt has emerged for the need of convention of corporate criminal liabilities, and there is no broad answer to this doubt. It is to be inspected and decided for each case, and after that, a decision must be taken with respect to the risk of enterprises. Commentators to this idea contend that the doctrine of corporate criminal obligation is totally superfluous on the company on the two grounds. Firstly, they contend that it is not the corporation that carry out crimes, the people do. Furthermore, that the retributive impact is borne by the investors and the buyers. It implies that the cost of corporate criminal fines and those is borne by the investors and the buyers for the demonstration of companies. In criminal law, corporate risk resides the degree to which a corporate as a lawful person, which can be subject for the demonstration and exclusion of the common individual it utilizes. It is viewed as a part of criminal vicarious liabilities. Then what will be the concept of corporate criminal liability? Corporations are becoming an integral part of our society, and with development of corporation, they have become significant factor in our economy. Our society run in the risk of getting victimized by these corporations, and they should be deterred too. The concept of corporate criminal liability is based on the doctrine of respondent superior. Respondent superior means that a corporation can be held liable for the act of its employee and agents working for the corporation. Apart from this, Section 11 of the Indian Penal Code defines a person as Section 11 of IPC has been defined as The word person includes any company or association or a body of persons, whether incorporated or not. This means that corporations have their own identity and they have separate legal personality, and also they are different from their members, and this is sufficient to make them held liable. If there is any connection between the criminal act of agent and his corresponding corporate duties, the corporation can be held liable for the conduct of the agent. For imposing the criminal liability on the corporation, it becomes necessary and essential that the act of the employee is conducted with the intention of incurring benefit to the corporation directly or indirectly. In addition to this, the corporation can be criminally held liable if it was found that the act was committed with the intention of obtaining some personal benefit, but it also ended up benefiting the corporation as well. This means that both benefits are going on, personal as well as corporation. Beside this, the doctrine of corporate criminal liability has faced many major issues throughout ages. Firstly, the failure to prove or identify the criminal intention of the agent or the employer, as it is very important to find the mens rea for the commission of criminal act to be proved as corporate or as a corporate are a separate legal entity. And secondly, the court required the accused to be physically present in the court when the proceedings are taking places, but this was not possible in case of corporation. Thirdly, the most important issue in the case of corporate criminal liability is the sanction. Yes, sanction, that is, a corporation cannot be imprisonment or put to death. Thus, the treat of imprisonment, which play a major role in criminal law, cannot be enforced here. There are few requisites which are necessary to be established before criminal liability, which can be imposed on a corporation of any other kind of legal entity. Firstly, act within the scope of employment. There are certain requirements which needs to be fulfilled for a corporate criminal liability arise. Firstly, the main requirement is that the employee committing the offense must be acting within the scope of the employment. This means that there must be a master and a servant relationship between them, which create a vicarious liability between them. That is, master and servant, and he must performing the duties which are authorized to them by their parent company. Secondly, benefit to the corporation. The second requirement which is needed fulfill for a corporate criminal liability to arise is that corporation should have received any benefit out of the act of the employee or the agent. It is not necessary that the company must have received any benefit or not. It is only necessary that act is done by the employee or the agent to benefit the corporation. There are various methods which the corporate can be held liable. They are which are collective or willful blindness doctrine. And what do we mean by collective blindness doctrine? This means that it is not necessary that an individual can be made liable for the act benefiting the corporation. There can be group of people which can be made liable for this, proving that each person of group has knowledge in totality. Whereas in willful blindness doctrine, the corporation is in knowledge of the illegal practice, but they turn the blind eyes toward that crime. In such cases, the employer as well as agent will be liable for the illegal practice. Apart from this, employee as well as the agent can be held liable for the conspiracy together in corporate criminal liability. What are the jurisprudential evolution in this? The controversy on corporate criminal liability in India began with the Supreme Court's decision in Standard Chartered Bank versus Directorate of Enforcement. In this case, the court held that Indian laws recognizing the corporation that corporation could be prosecuted and convicted for an offense which set out a mandatory sentence of imprisonment and a fine. This judgment further clarified that in case where the offence imposed both both imprisonment and fine, the court will be entitled to apply only the fine in situation where the impungent party was a corporation. This marked as a convergence from the establishment line of precedence, where court refused to convict corporation for crime as the court could not by discretion decide to impose only the fine and not the mandatory imprisonment. 6 years later, in Iridium case, the Supreme Court for the first time attributed mens rea to Indian corporation. In Iridium case, a company was charged with the offense of cheating and criminal conspiracy, and on the basis of alleged false representation made by the company in its prospectus in connection with the offering of securities to the people. The Supreme Court held that a corporation is virtually in the same position as an individual and may be convicted under common law as well as for the statutory offences, including those requiring mens rea. This judgment held that a corporation would be held criminally liable when an offence is committed in relation to the business of the corporation by a person or a body of persons in control of its affairs, who would therefore be treated as the alter ego of company whose mens rea could stand attributed to the company. However, the Supreme Court noted that in such circumstances, it is important to ascertain to discover that the degree and the control of person or assemblance of person is so intense to the point that a corporation might be said to think and act through the persons or body of persons. Then what will be the test to determine whether the corporate criminal liability, whether this corporation has a criminal liability or not? We have find out the three tests. First is identification test, second is aggregation test, and third is respondent superior test. First, we talk about the identification test. In Tesco Supermarket Limited case, the person who act is not speaking or acting for the company. He is acting as a company, and his mind which direct his act is the mind of company. If it is guilty mind, then that guilt is the guilt of the company. This test is otherwise called as alter ego test, and furthermore as directing mind and will hypothesis. This test is also applied in the English code for identification or controlling or coordinating minds of the organization so as to determine the criminal liability of corporation. Then comes the aggregation test. This might be situation where a corporate wrong might be the consequences of combination of guilty mind of numerous people by amazing the act of two or more persons. The actus reus or man reus can be taken out of the conduct and knowledge of several individuals. And in United States versus Bank of New India, the court appeals confirmed that a collective knowledge is appropriate because corporate would divide duties and avoid liabilities. This test can be applied in Australia, but it was rejected in England. And third one was respondent superior test. The court has provided various reasons to justify corporation's liability for the act of agent. A corporation can be held liable for the act if the agent commits a crime within the scope of employment with the intention to benefit the corporation. When now we talk about the India and what are the, we can say, what is the development in the India? In India, prosecutions for the crime commit out in embassy according to the provision of IPC 1860 under the Indian Criminal Justice. Section 11 defines the expression of the person, and it incorporates any company or affiliation or body of persons. It could be either incorporated or not. Thusly, the corporations can be prosecuted for the commission of crime. Be that as it may, the position of criminal obligation of corporations need to be determined whether the corporations carry out offences where the penal code demands for a mandatory imprisonment and fine, Some landmark judgments settles this issue and aided in the advancement and development of corporate criminal liability. In case of Assistant Commissioner versus Valiappa Textile Limited, it was held by a majority that company cannot be prosecuted for the offence which requires imposition of a mandatory terms of imprisonment coupled with fine. Where the punishment provided it both imprisonment and fine, the court can not only impose fine. This difficulty was noticed by the Law Commission of India, and in its 41st report, the Law Commission of India suggests an amendment to Section 62 of IPC by adding the following lines. In every case in which the offence is only punishable with imprisonment or with imprisonment and fine, and the offender is a company or other body corporate or an association of individual, it will be competent to the court to sentence such offender to fine only. The apex court in Standard Chartered Bank and others case made this scenario very crystal clear. It has overruled the past perspectives with respect to the principle of corporate criminal obligation, and the court held that there is no sweeping insuspectability for any company from the indictment of offences in the light of the fact that the arraignment requests a required detainment. The Peak Court chose that in instance of offences which command both detainment and fine, the companies ought to be roughed with a fine. In case of Iridium India, a corporation is virtually in the same position as any individual may be convicted of common law as well as statutory offences, including those requiring mens rea. The criminal liability of corporation would arise once associate offence is committed in reference to the business of the corporation by someone or body of persons on top of things of its affairs. In such circumstances, it would be necessary to ascertain that the degree and control of the persons or body of persons is so tense that a corporate may be said to suppose and act through the person or body of persons. Section 11 defines that person would come with any company of association or body of persons with corporated or incorporated, whether corporated or not. Henceforth, corporation can be prosecuted under IPC for the crimes committed. It is an undisputed fact that companies can't be prosecuted for crimes done by people like assault, where only punishment can be contemplated in IPC is imprisonment. At that point, the gray area was that to decide the situation of the cases where the corporation commits offences, where the IPC demands a mandatory punishment of both imprisonment and fine. Some milestone decisions settled the issue and aided in the development of corporate criminal liability. As we have as I have told you earlier, that in the case of Assistant Commissioner versus Valiappa Textile Limited, the court by a majority of 2:1 held that since corporation could not imprisonment, they could not be prosecuted for an offence where IPC commands an imprisonment. The contradicting judges saw that on the grounds that the corporation cannot be imprisonment can never be an explanation behind for an observation that the corporation cannot at all be prosecuted, things considered. What the judge additionally included here, that the court has two capacity to perform. The first is to decide whether the accused is guilty of having committed the crime, and this conclusion has to be made on the basis of evidence produced before the court. And furthermore, the function is to award a sentence for the offence for which accused is discovered guilty. And he clarified that court would be shrinking their responsibility of imparting justice by holding that prosecution of a company is unsustainable merely on the ground that being a juristic person, it cannot be sent to jail to undergo the sentence. Companies are going in size and having huge resources and finance at their command. In the course of their business activities, they may sometimes commit breach of law of land or endanger others. More than 4,000 people lost life and thousands others suffered permanent impairment in Bhopal on account of gross criminal act of multinational corporation. It would be wholly wrong to allow a company to go scot-free without even being prosecuted in the event of commission of a crime, only on the ground that it cannot be made to suffer part of mandatory punishment. Examining these functions alongside concerns, the judge observed that the corporate should be punished with a sentence of fine if the court finds them liable. When we say about the strict interpretations, the same issue was detected in the Standard Chartered Bank case, where the Supreme Court overruled the Viliappa case and held that there is no blanket immunity for any corporation for the prosecution of offences just because the prosecution demands a mandatory imprisonment. And the court decided that in case of offences which mandate both imprisonment and fine, the corporate should be punished with a fine, and the component of mens rea has assumed a vital job in the development of corporate criminal liability in India. It likewise includes that the corporation might to be said to act and think thoroughly considering the body of persons controlling it through the mens rea of body of persons in control out to be discovered, which is for all intentions and purposes viewed as an indistinguishable position as the corporation. When we are fixing the liability, an Indian court has endeavored to distinguish the controlling and the coordinating mind of companies, and this rule is utilized in different statutes. The issue around there will be whether the coordinating persons approved to follow up in the interest of the firm would be prosecuted with the corporate was not charged. In the case of UP Pollution Control Board case, the respondent industrial unit has been released. It's a very harmful and contaminated exchange effluent into the stream through a local drain channel. This discharge done by the industrial unit made a breach of Water Prevention and Control Pollution Act of 1974, and the court held that the directors and the people in charge of organization that the company's act could be prosecuted even if the company was not prosecuted. The court also added that a technical fault on the part of company to furnish the requisite information called for by the board directed for making a formal amendment by the applicant and substitute the name of owing industrial unit. The objection was inadequate yet was incurable, and the person responsible for the conduct of corporation should be prosecuted. When we talk about the corporate criminal liability, there arises the twin model of corporate criminal liability. One is the derivative model and second is the organizational model. The derivative model is usually an individual centered model, and it derives to attach the liability to the corporation, and this is because only an individual connected to the corporation can incur some liability for which an individual can be punished. And a derivative model can further be subdivided into vicarious liability and identification model. Means we have a twin corporate criminal liability. First is derivative, which is further divided into vicarious liability and identification liability. The concept of vicarious liability is based on two maxims: quid facit alium facit per se, which means he who acts through another shall deem to be acted on his own, and secondly, respondent superior, which means that the corporation can be held liable for the act of employee and its agent, which early states that let the master answers. Then in identification doctrine, it is an English law doctrine and which supports in finding and identifying the certain key persons of the corporation who has acted on behalf of corporation, and those conduct and state of mind has been attributed to the attributed to that of corporation. The principle of identification doctrine has been originated by the civil case Leonard Carrying Company Limited, and where it was held that in order to prove that a corporation has actual fault or privity, the privity of company's manager was the privity of the company itself, and added that the person who is really the directing mind and will of the corporation, the very ego and center of the personality of the corporation. In totality, it was held that a company, being a legal institution, cannot operate without human interventions. It cannot take actions nor have a state of mind. The principle, which is sometimes known as the alter ego doctrine, was established from here. We are still confused between vicarious liability and identification doctrine, leading to the fact that a comprehensive code needs to be drafted based upon the corporate fault principles, so that the intent and the alter ego of the wrongdoer can be punished accordingly. Then comes the second doctrine, second theory, organizational theory. It focuses and takes into consideration the entire corporation and not just an individual, unlike the identification theory. And according to this theory, a offense requires mens rea, that is a mental state to commit a crime, along with actus rea, that is a physical action. But when it comes to make the corporate criminal liability, the problem arises that a corporate, which is a juristic person, how could possess requisite mental state to commit a crime? Before organization model, derivative model was the only attribution to know the mental state of the corporation. But then with this model, there was the another way that could be proving that there exists an environment in the corporation which direct and tolerated and even encouraged the non-compliance of specific law, which made it offense. Moreover, a physical act that too is required to complete the requirement of commission of an offense, and can be derived or rather be proved from the act of employee or the agent or director or the officers. Thus, culture of the corporate is to be seen while determining its criminal liability. Once again, the culture of the corporation is to be seen while determining the criminal liability. Thus, corporate culture may be reason for the commission of an offense, firstly by providing the environment and the encouragement that it was believed by the offender working at the workplace, and secondly, when the corporation has created an environment which lead to the commission of the offense or the crime. Thus, the corporation culture plays a vital role in commission of offense at the corporate level. And then what are the new approaches in corporate criminal liability? The judgment in the SBM judgment. SBM means Sunil Bharti Mittal. I think everybody knows about this. Bharti Airtel. The judgment arose from a special leave petition against the order of a special court who took cognizance of allegation made in the 2G spectrum allocation scam case and issued summons to Bharti Airtel Limited, SR and Sterling Cellular for having defrauding the government of India in the auction and allocation for 2G spectrum. Mr. Sunil Bharti and Mr. Ravi Ruya were at the relevant time the chair cum managing director of Airtel and director of Sterling Cellular respectively. In light of this, in the perspective of special judges, these people who held top administrative posts with the arrangement organizations were ipso facto represented as the coordinating mind and will of these organizations which had propoundedly committed the offense. Accordingly, the special judge issued summon to these people as well, thereby imputing the criminal act of the company to the people who held top marginal post. In doing so, the special judge applied the principle of attribution developing in Iridium case. In reverse, moving from the criminal act of company to these deemed to be controlled without a specific finding that these people were indeed guilty as such. Now, I have written the conclusion. that India is attempting to slow down the unrelenting pace of corruption in its government, which has been plagued by a rash of large scale corporate scandals. In this context, it is necessary to consider not only the criminal liability of individual director or agent of a business, but also the criminal liability of corporate itself. Many times, the corporate has reaffirmed and strengthened the concept that corporations have criminal liability and can be tried for criminal offenses. It does, however, protect directors and workers who, despite being the company's alter ego, are not legally accountable unless there is an express statute stating otherwise. To the relief of corporation, the court has taken a balanced approach, not shying away from taking action against a high officer if it is proven that the officer was culpable for the crime as seen above. At the same time, they have shielded top officials whose involvement could not be proven personally. Even though the ruling is consistent with the criminal law principles, it is counter to argue that an artificial person would only be charged with criminal accountability while the natural humans in charge of the company's business may get away with it. As previously stated, the primary premises of strict interpretation of criminal statute binds the hands of justice. With corporate scandal appended, it's more important than ever to revamp the regulatory regime and statutes to make corporate criminal liable more robust and purposeful, while also striking a balance by relieving executives of the fear of being held criminally simply because of their position. While combating crime, it is critical for legislation to achieve a balance between the functioning of society and the overall benefit of the economy. As a result, major changes in relation to criminal liability of Indian corporation must be adopted in order to strike a balance, as the statutes are out of synchronization with these developments. Thank you, Jayashree ma'am, for giving me an opportunity to speak on corporate criminal liability.
Thank you, Dr. Sanjula. You've been so nice and very descriptive, enlightening, and elaborative your talk was. And indeed, you have thrown light on the statutes of the defendants that they take regarding omission and commission of their being into liability, or stating how they would defend themselves in the corporate system of mens rea. So that's wonderful on your part. I invite next speaker, Ram Sharnagat Thakur Saab. He is an ex-secretary of the Council of Pharmacy of India.
One second. Just, am I connected or?
Yes, sir, you are connected.
But anyway,
I'll read out your introduction meanwhile.
Okay.
So pardon me for interrupting in between. So Professor Dr. R.S.Thakur Saab, he basically belongs, or you may say his roots are from Bihar, India. And currently he is a chief editor, Journal of Pharmaceutical Research in Kurupanidhi College of Pharmacy, located in Bangalore. And his educational qualifications are D Pharmacy from Pharmacy School of Patna, then Bachelor of Pharmacy from Jadavpur University, Kolkata, then Masters of Pharmacy again from Jadavpur University, Kolkata, then his doctorate from also Jadavpur University, Kolkata. So his alma mater is Jadavpur University, one of the very, very renowned universities, and everybody craves to go there to have some enlightenment regarding academia and their knowledge. So his professional recognition started from being his into associateship diploma of Institution of Chemist India, then fellow of Institution of Chemist India, chartered chemist Institution of Chemist India. He is also the pharmacist, indeed, for the government of Bihar, the Department of Revenue, NTC Hospital, Bathia, Champaran, Bihar. Then he worked for 9.5 years in Department of Atomic Energy, Government of India. Then later he extended his services as manager in the RB Laboratories, Government of India. And then also as a manager in senior research fellow in Jadavpur University, Calcutta, Assistant Secretary, Pharmacy Council of India, New Delhi. He worked there for around almost 8 years. Then Secretary, Pharmacy Council of India for 2.5 years, and then Director for 5 years in Santosh Medical College, Ghaziabad, Uttar Pradesh. He was also the professor and head of the Department of Pharmaceutics, Krupanidhi College of Pharmacy in Bangalore, Director, LB Institute of Nursing Sciences, Patna, Bihar, then Dean, Ranchi College of Pharmacy in Jharkhand, India. The most amazing thing about him is that he's so much popular in our Bhupal Nobles University that without him, none of the work is, being recognized unless he tick mark it as an acknowledgement of accreditation or recognition. So I invite Dr. Thakur to please take the stage and deliver your lecture.
Thank you, madam. Thank you so much. Respected Chief Guest, Dr. Dilip Nandekoelyar, eminent speakers of today's session, the Vice Chancellor of Bhupal Nobles University Udaipur, Dr. Jayashree Singh, coordinator of this program, the galaxy of legal luminaries who are participating in this, all other participants, my dear friends. I'm thankful to the organizers and the university for giving me this opportunity. And the topic I am going to deliver is liability in medical profession related to the negligence or malpractices or the medical errors committed by the doctors. And this subject is very, very important in view of the fact that studies in United States of America reveal that medical errors are third leading cause of death in US after heart ailments and cancer. This is a third, more than the accidents and other things. So that is the magnanimity of and the importance of this issue. And throughout the world, in different jurisdictions, different laws are there which govern it. And as medical profession is a regulated profession, in India now National Medical Commission is there, and its predecessor was Medical Council of India, which was regulating the registration of medical practitioners. And they had, in 2002 itself, they fixed the regulation relating to professional conduct, etiquette, and ethics of medical practitioners. And now that is adopted by the National Medical Commission, which came in effect on 25th September 2020. So in that perspective, the negligence or the malpractices committed by the medical doctors, against them disciplinary action is taken by the National Medical Commission and earlier by the Medical Council of India. Other is, if the doctor is employed, then the service rules of his employer, that also the administrative actions, disciplinary actions from the employer also they face. Moreover, depending upon the nature of injury or affliction which his patient has faced, depending upon that, he is also liable for compensation, for which people move to consumer courts or the civil damage suits are filed and litigation continues. Moreover, criminal liability is also there upon doctors depending upon the nature of the damage done to the patient. So this is the glimpse of things, how this medical profession and
negligence there is relating to the fate of the doctor himself, the medical professional. And that's why every medical professional, he should be very honest in dealing with his professional ethics, in complying with those ethics, and dealing fairly with his patients. Of course, no doctor may want that any harm should be done to his patient. Always they think for the welfare of the patient, but still errors are inevitable, and doctors cannot be an exception to that. So, especially in the last century, in the 20th century, there has been enormous litigation relating to lapses on the part of medical doctors, and huge amounts of compensation, which at times have ruined not only the practice of the individual doctor, but the fate of the hospitals also have been badly affected by litigation and huge compensation imposed upon them by various courts. So, in light of that, one school of thought is there: if doctors are subjected to so much of litigation, and if they are in panic, they cannot do professional justice to their patients. A doctor is scared of every action of act of omission and commission by him. He cannot do fair justice to his patients, and then there will be a standstill in the arena of treatment of the patient. And this point has been well taken up by the courts of law, and the courts of law have made it very clear that law is only a watchdog. It's not a bloodhound. So the medical practitioners should deal fairly with their patients, and they should not be scared of the consequences, because whatever he has done based on his knowledge in the field of the medicine, in that particular specialty of the medicine. And there cannot be compulsion that he has to follow exactly what other practitioners in the same vocation they are practicing, but they must be up to date. The practice they commit, that is a standard practice at large, and therefore if that continues, then doctors usually will not be subjected to criminal litigation or criminal prosecution. So the courts has clearly indicated that as long as doctors do their duty with reasonable care, they will not be held liable even if their treatment was unsuccessful, because 100% success is never expected, not possible also. There will be, because every day new medicines are coming, new formulations are coming, so complexity of treatment is increasing, new diagnostic tests, methods, so complexity is increasing, and when very large number of options are available for the doctor to arrive at a particular therapeutic regimen, then there is every probability that deviation will be there in the style of prescribing of one doctor compared to other doctors. So that cannot be the yardstick that this person has neglected. That neglect has to be proved well. So simply because a patient has not favorably responded to a treatment given by a doctor, or a surgery has failed, the doctor cannot be held straightway liable for medical negligence by applying the doctrine of res ipsa loquitur. No sensible professional would intentionally commit an act or omission which would result in harm or injury to the patient, since his professional reputation would be at stake. A single failure may cost him too much, and therefore doctors themselves also are very, very cautious about avoidance of any negligence or malpractices on their part. So, as we know, these liabilities attached to various laws. Civil laws are applicable, consumer laws are also applicable, criminal laws are also applicable, disciplinary action by the Medical Council or the National Medical Commission, that is also applicable, as well as employers service laws, those are applicable. So multiplicity of consequences are there if any negligence or malpractice is done by the doctor, and therefore every doctor takes adequate care. So in terms of liability, a medical practitioner is not liable to be held negligible simply because things went wrong from mischance or misadventure or through an error of judgment in choosing one reasonable course of treatment in preference to another, because a vast complexity of medicines are available for treatment of same ailment, and therefore a compulsory yardstick cannot be there that this medicine is correct for this patient and this is not correct. The medical practitioner would be liable only where his conduct fell below that of standard of a reasonably competent practitioner in his field. That is, his knowledge should be up to date, and that's why the medical council or registering authority, they conduct continuous education also for the medical practitioner for renewal of the registration of medical practitioners, and that keeps them abreast with the latest advances in their field, and therefore the latest treatment they adopt from time to time. But there are some instances where lapses are ipso facto proved. One such instance may be if the surgeon has left surgical gauze inside the patient after an operation, then he is definitely liable for action. And this matter was taken up by Supreme Court in Achyut Rao, Haribhav, Khoda and others versus the state of Maharashtra and others. A doctor will be held liable if he operates on the wrong part of the body, then he is definitely liable. And the third point which was highlighted by the court is a doctor will be liable for criminal liability will be there on the doctor if he operates on someone for removing an organ for illegitimate trade. So in all those cases, the liability is definitely there, but that has to be proved. Nature of liability, as already I have called that 4 types of this liability happen: disciplinary action by medical council, even leading to cancellation of the registration or suspension of his registration for practice, and administrative, civil liability and criminal liability. Consumer Protection Act also is applicable on the basis of deficiency of service, and the consequences there are that huge penalties are imposed by the consumer forums. So in dealing with these professional liabilities, the liability that arise due to professional failures resulting in damage to the patient are required to be compensated monetarily either by the professional himself, or if he had insured for such lapses, then the insurance company, if these terms are mentioned in his policy, then the insurance company is liable to pay that. And in a landmark judgment, the Honorable Supreme Court ruled that doctors should not be held criminally responsible unless there is prima facie evidence before the court in the form of a credible opinion from another competent doctor, preferably a government doctor in the same field, that is same discipline of a specialization or super specialization of medicine, supporting the charges of a rash and negligent act on part of the doctor. So only in that limited dimension, the doctor will be responsible for criminal liability. negligence in itself is a very vast term, and here lapse may be either in prescribing, either in surgery, either in adherence of the medication by the patient, either in communication gap, or on so many counts, which may lead to not curing the disease, even at times side effects, other complications leading to other diseases because of the medication, that is called iatrogenic diseases in medical term. So all those relate to the real the vast area in which the medical liability is associated, and this environment has created a somewhat atmosphere of suspicion against each and every prescription of doctor, each and every procedure conducted by a doctor. So that environment is not truly good from societal point of view, because that affects their expertise, not only expertise, but their confidence also in treating the patient. And at times those lapses are considered if the complaint is made to the medical council. Now the each state they have medical councils, so the real disciplinary proceeding starts from the state medical council, and if they have taken decision on that, against that the doctor can go in appeal into the National Medical Commission, and all these are decided under the professional conduct, ethics and etiquette regulations of Medical Council of India of 2002. So for aggrieved doctor also there is remedy, for the aggrieved patient or the party of the patient, for them also there is provision of relief. Now on international level, how these medical negligence or malpractices they are regarded. So one case is Hunter versus Henley of 1955, where in which Lord Clyde, he states, in the realm of diagnosis and treatment, there is ample scope for genuine difference of opinion, and one man clearly is not negligent merely because his conclusion differs from that of other professional men. The true test for establishing negligence in diagnosis or treatment on the part of a doctor is whether he has been proved to be guilty of such failure as no doctor of ordinary skill would be guilty of if acting with ordinary care. That is the minimum standard practice. If that is followed, then that doctor is not guilty. That is the ruling by Lord Clyde in Hunter versus Henley case of 1955. Also, the basic principle relating to medical negligence has been illustrated in Bolam rules. The judgment of Justice McNair in Bolam versus Free Hospital Management Committee of 1957, and the judgment states, where you get a situation which involves the use of some special skill or competence, then the test as to whether there has been negligence or not is not the test of man on the top of a Clapham omnibus, because he has not got this special skill. The test is the standard of the ordinary skilled man exercising and professing to have that special skill. A man need not possess the highest expert skill. That is what I was telling, the minimum standard of practice prevailing in the contemporary medical arena, that a doctor has to, that service must be given, not the highest expertise or skill is expected of him. It is well established law that it is sufficient if the exercise the ordinary skill of an ordinary competent man exercising that particular art is performed. And this Bolam test has been approved by the Supreme Court of India in Jacob Matthews case, which I will deal with in the next ones. So in Jacob Matthew case, that here the Supreme Court 3-judge bench in Jacob Matthew versus the state of Punjab and another in 2005, the Supreme Court came to the conclusion that the practitioner must bring to his task a reasonable degree of skill and knowledge, and must exercise a reasonable degree of care, neither the very highest nor a very low degree of care and competence in what is the law requires. So that is the extension of the Bolam that is here, seen here. Another case is Halsbury's Law of England. The degree of skill and care required by a medical practitioner is stated in this case as follows in Halsbury law. The practitioner must bring to his task a reasonable degree of skill and knowledge, and must exercise a reasonable degree of care. Neither the very highest nor a very low degree of care and competence, judged in the light of the particular circumstances of each case, is what the law requires. And the person is not liable in negligence because someone else of greater skill and knowledge would have prescribed different treatment or operated in a different way. Nor is he guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art, even though a body of adverse opinion also existed among medical men, because that is likely to exist. And that's why the Supreme Court has also held that the highest skill or expertise is not required, but the minimum standard that has to be demonstrated by the practitioner. Deviation from normal practice is not necessarily evidence of negligence. This is very emphatically said by the court. To establish liability on this part, that basis, it must be shown 3 points have been emphasized, that is, there is a usual and normal practice, that the defendant has not adopted it, and that the course in fact adopted is one no professional man of ordinary skill would have taken had he been acting with ordinary care. So if these 3 are proved, then only the liability arises, and the onus of proving is on the plaintiff or the complainant. Another case law in Eckersley versus Binney of 1988 states, from the general statement, it follows that a professional man should command the corpus of knowledge which forms part of the professional equipment of the ordinary member of his profession. He should not lag behind other ordinary, assiduous and intelligent members of his profession in the knowledge of new advances, discoveries and developments in his field. He should have such an awareness as an ordinary competent person would have of the deficiencies in his knowledge and the limitation on his skill. He should be alert to the hazards and risks in any professional task he undertakes, to the extent that other ordinary competent member of the profession would be alert. He must bring to any professional task he undertakes no less expertise, skill and care than other ordinary competent members of his profession would bring, but need bring no more. The standard is that of the reasonable average. The law does not require of a professional man that he be a paragon combining the qualities of a polymath and a prophet. So in legal parlance, these are very, very illustratively conferred and inferred by courts across the world that doctors in general should provide the practices which an average practitioner will provide. If it is below that, then only the liability of negligence or malpractices loom large upon him. In Jacob-Matthew case, the court had said for civil liability only damage can be imposed by the court, but for criminal liability the doctors can also be sent to jail apart from the damages or the fine which may be imposed on him in a civil suit or by the consumer fora. At the same time, the rider is also there, that how the criminal implication or criminal prosecution shall, for that minimum requirements, that in each and every case, not that a state where he has to be sent to jail. So that also has been fixed, criteria has been fixed for that by the court. The Supreme Court in Jacob-Matthew case has also stated that a medical practitioner faces with an emergency ordinarily tries his best to redeem the patient out of his suffering. He does not gain anything by acting with negligence or by omitting to do an act. Obviously, therefore, it will be for the complainant to clearly make out a case of negligence before a medical practitioner is charged with or proceeded against criminally. That is, I was telling that a minimum a rider has been fixed for charging in criminal prosecution. A surgeon with shaky hands under fear of legal action cannot perform a successful operation, and a quivering physician cannot administer the end dose of medicine to his patient. So doctors also should not be scared too much by the consequences of his practice, otherwise the medical services will be badly affected. If the hands be trembling with the dangling fear of facing a criminal prosecution in the event of the failure of the surgery, for whatever reason, whether attributable to himself or not, neither can a surgeon successfully wield his life-saving scalpel to perform an essential surgery, nor can a physician successfully administer the life-saving dose of the medicine. Discretion being the better part of valor, a medical professional would feel better advised to leave a terminal patient to his own fate in the case of emergency where the chance of success may be 10% or so, rather than taking the risk of making a last-ditch effort towards saving the subject and facing a criminal prosecution of his effort if his effort fails. So such timidity forced upon a doctor would be a disservice to the society, as I was telling earlier. So these are held by the court. When clear negligence is established, for that also, in Indian Medical Association versus V.P. Santha, Supreme Court in 1995 has fixed the criteria is clear negligence is proved if wrong limb has been removed, the surgery has been done on the wrong part of the body, if the performance of an operation on the wrong patient has been done, instead of Ram, Sam was operated upon. So that is clear negligence, and there this criminal offense it tantamounts to. Giving injection of a drug to which, the third point, giving injection of a drug to which the patient is allergic without looking into the outpatient card containing the warning about such medicine. So then clear-cut negligence is there. And the fourth point is use of wrong gas during the course of an anesthetic use, because so many gases are there. In case of laparoscopic surgery, carbon dioxide is pushed inside the abdomen to flatten it. And if that carbon dioxide, instead of the anesthetic gas, nitrous oxide, that is by mistake given, then by inhaling carbon dioxide, the patient will die on the table itself. So those cares have to be taken by the practicing doctor, the surgeon, the anesthetist, and all others or the medical practitioner in prescribing the medicines of a standard. So these are some of the glimpse of the situation which create negligence, malpractices on part of the doctor, and which lead to litigation, compensation, and even if criminal offences are there, then jailing the doctor. So all that happens, and in this parlance of the vast deviation, that there was a time when people revered doctor as next to God, and whatever the doctor prescribed, they were blindly consuming it and not without any complaint. But nowadays everybody is too much conscious and cautious, and at times the laws are misused also, just for purpose of litigation or harassing a particular doctor. Also, so many complaints are made. So if we visit in the Vedic era, then the in Vedic era, how the doctors were and the medicine was revered can be concluded as Aushadham Janavi Toyam Vaidyo Narayano Hari. Medicine was revered as the holy water of Ganges, and the doctors were considered next to God himself. But in Kali Yuga, now what people think of the modern doctor is, Doctor Namastubhyam Yamaraj Sahodara Yamo Hantum Prananam Tvam Pranam Dhanadicha, because both ways the person lose. Life also is lost, and hefty bill is also there, so that entire family is also devastated for all times to come. So change of situation has been there, change of setup of mind has been there, and all these have penetrated in the society because of commercialization of medical treatment, emergence of corporate hospitals, and then targets are fixed before the doctor, since instrument and this diagnostic equipments have been purchased. So compulsory tests, unnecessary prescribing too many medicines, too costly medicines. So all those things, malpractices are of course there. It's not that not there, but not always. That law is misused also too much, and each and every person in his life needs services of doctors. So it should be seen from a real perspective that doctor is not contemplating any harm to anybody, rather he tries his best. It is for you that you select a proper doctor, a proper specialist who is renowned in that field and who is success of practice has very high rate. So it all depends upon that. So these are the few points which I wanted to discuss about the negligence, malpractices, and its consequences upon doctors. Thank you all. Thank you for the patient hearing. Thank you so much. If any question is there, then.
Yes, Doctor, we will take later on the questions. We are already getting for 15 minutes late in all our continuous sessions that we are holding. I would like now to just stay tuned and be there. We will take up our comments, everything later on. Meanwhile, I welcome and good evening our Professor Dwarka Prasad Uniyal, the bona fide citizen of Udaipur. It's a pride and privilege that without any, we cannot finish or complete any of our symposiums, especially online, if we are in hybrid mode without you. So thank you for coming in. Let me just give you a brief profile of yours. Dwarka Prasad Uniyal Sahab is currently the Pro Vice Chancellor in the field of development and leadership and founding Dean, School of Economics and School of Business, Rashtriya Vidalaya University, Bangalore. He was formerly Dean of University in Pune, and in his academic career, which has been spent for 2 decades now, he has taught at premier business schools like IIM Kashipur, where he was Assistant Dean of Executive Education and headed its Dehradun campus. MICA Ahmedabad also, there he also extended his consultancy and educational services. Then SPJIMR Mumbai and SP Jain School of Global Management Dubai. So Professor Uniyal was also a part of OB Jindal Global University as a founding assistant dean of Jindal Global Business School. In the past, he had been invited.
Lose time if we let's. I think we should get on with our.
Okay, so we'll cut short your profile. We'll come to know through your stories.
Yeah. Good evening, everyone, and thank you, Dr. Jayashree, for having me here. I have never felt more fish out of water than today when there are meeting all the legal luminaries, people who are very expert in different areas. I'm the last person to talk about anything on criminal liabilities and the focus of this particular very specific subject-driven conference. So what I would do very specifically here, Dr. Jayashree, in next 5-7 minutes, is that first and foremost, always if any of the institutions in Udaipur call me up for anything, even if I'm out of my wits, I always say yes. And I'm a poet, so probably I'll weave through some narratives and the stories around it. So I was listening to just give me a sec, ma'am. Just give me a sec. I was listening to a couple of the speakers earlier, and one of the things which caught my attention was the Bhopal gas tragedy and the stories about the criminal liabilities and the justice being done or injustice being done at that point of time. And thank you. And some of those things have stayed with us because we have seen the kind of criminal justice system which exists. I was lucky to be at OB Jindal University and the law school where I've participated and heard and learned some of these issues which were discussed threadbare by the lawyer friends of mine and the experts in that particular sense. So I think one of the things which as a layman, and there are a lot of legal fraternity and lawyers here, is the fact that half of the time I realized that the legal terminology itself is extremely complicated for a lot of us to even understand. There are people who have suffered. There is a human element to it. And yes, there is a legal language which is to be done. I think as a fraternity, my request to all of you who are very senior lawyers or professors of law or others, or law education itself, is to simplify the process through which people even understand the basic law. I think there is a need for a creation of a portal or a technology platform which creates something called law for dummies or law for understanding and making it much simpler for others to know that half of the time, a lot of people don't even understand law of the land. I think legal literacy itself should be introduced at school level itself, which is just like digital literacy and financial inclusion and literacy should be part of every school through NEP. I think it's very important to also from the childhood itself, we need to know our laws, our rights. We should be knowing about the various aspects of criminal and civil laws themselves, because I think we are very, very law ignorant country. And including myself. And as we keep moving up, I think in terms of taxations or even simple acts like traffic violations and others, we are really, really law ignorant country. And I feel that there is a lot of work to be done by legal fraternity, universities, clinical practices and others to make it first accessible and make it simpler for others to try and understand this, which is very, very critical. It's not law needs to be learned by everybody, at least the basics of it. And I think all of you and these platforms like these can be made more available to general public, because I was listening to some of those speakers before me, Dr. Ram, and I think Dr. Sanjula or a few others were talking. I think they were making immense sense about the kind of cases they brought in. I was very intrigued by, because I teach a subject called retail, and I was very intrigued by as an organization, as an individual like Tesco, and do they have their brain of their own, and do they? So it's very interesting to try and see, because this also would come to technology platforms like like for example Twitter, like for example Facebook, like in digital, so many things are happening, and they're unaware of the law of the land, that they need to have a compliance officer, or they need to really work. They've gotten into trouble with the courts because they were not following the law of the land. And I think many of these legal except the simple business laws we teach in business schools, I don't think we do a justice to the law education in the business schools and the universities also, where interdisciplinary knowledge needs to come in, not just for the law education, but I think a lot of other disciplines require quasi-law knowledge and education, so that wherever they are using this, they are very much at length at the people were talking about employer-employee relationships and the bonds and things. I think this again is very, very misconstrued and misunderstood about the liabilities on an employer, what is needed, the code and the guidance which is need to be there. I've worked in some organizations in the past where people were misusing the laws which existed for the benefit of the people, and they ended up harming the institution. Like, for example, I know for sure in one of the organizations, a fellow faculty member was essentially putting up RTIs against so many of us, and only to realize that they were all frivolous RTIs. Just to give an example, I headed the international relations for an institution, and for that I had to travel to various places, meet industries and others. The ITI was put in saying that, Professor Uniyal, you traveled to so many institutions, so many countries, whatever the cost incurred by the public money was this. Tell me about how many jobs you've been able to get. How many? What is the quality and the quantity of jobs at a ROI level. I think these things are make sense only at over a period of time. But you put up something misusing the RTI law to harass people. I think we have seen this, which needs to be, and people don't know about it. Similarly, the POSH laws are very, very critical for people to understand. The gender inclusivity laws are very, very important for people to understand. It can be misconstrued from both sides. The Me Too movement has given us the opportunity to come up with the guidelines, the POSH guidelines, and so on and so on. So I think law is everybody's business, and I would rather request all of you who are all legal luminaries here to engage with non-law people like us in universities and colleges who don't have law departments, to help us in create specific courses, certificates, and also generally improve the law knowledge from the childhood itself, from college itself, from graduation itself, so that all of us don't end up getting on the wrong side of the law. 95% people don't want to do anything against the law, but most of the times they're unaware and ignorant about it. So that is something which I personally feel is very, very important. And such conferences, such seminars which you're doing it, ma'am, BN universities and others, my congratulations to the whole team. Unfortunately, I think you had Dr. Anand Paliwal as your expert yesterday. I wish Anand was here. Anand and I studied in school together. I'm a business dean. He's a law dean. He was the dean of the law school, and we would have engaged and interacted. But having said that, I wish all of you a huge success for this conference and deliberations. I hope to read the proceedings, because I'm a reader. I'm a very voracious reader. I would love to read the proceedings and the papers you are presenting, empirical or theoretical. And I wish BN University and Madam Jayashree and others congratulations first, and hope that you would continue to create such platforms for people to come together. And Dr. Ram, I think, is based out of Bangalore. So, sir, a warm welcome to you, to my university. Anytime you are at Mysore Road, please drop in, give me a buzz, and it would be our pleasure to host you, and probably we can learn a lot of things from you as well. So, ladies and gentlemen, thank you. Good night. And thank you for having me here. Somebody who is completely ignorant about a lot of your expertise in this particular case.
Yeah, I think, yeah. Thank you. Thank you, Dr. Uniyal. It's wonderful. You have really, in a simple, free thought and free expression, given us very important few tips and inputs that how our Professor Salvatore can motivate through this symposium, and after pointing out certain recommendations that how we can go ahead with in different departments with the legal law knowledge. It's very necessary, because whenever I enter in my classes of law students, I always say that whatever word you speak or whatever language you utter, it's a law. Only thing is that you have never been able to understand that every word is a synonym to law. You cannot ignore your words. So it's very necessary that from graduate level now, the students should be inculcate this kind of spirit. And number two, that what you have very importantly notified to us, that generally the civic sense has been already been in school level or in other levels, been taught in the form of framing before us the constitutional structure of administrative bureaucracy. So this is not required now, because we have crossed that kind of, you may say, no, kind of a wall that has been there before illiterate and non-illiterates, or you may say. But I think now we need the language of law to be taught to all kind of or all category of students in different disciplines. So definitely, our Salvatore sir, are you there? Could you come in and say something to Dr. Uniyal? Salvatore sir? Perhaps he might be.
Yeah, he might be off. Yeah.
Yes, here he is.
Can you, hello? Can you hear me?
Yes, we can, sir.
Yes, sir. Yes, thank you. I'm experiencing some troubles with connection, and yes, I really appreciate the last lecture. In order that because I believe that it's actually focused on something that is very important, and how should we enlarge our education about children, about younger men, let's call them in this way, about their status of citizen, their way of interacting in their closer or larger society, and of course, law is one of these ways. Of course, I wish just to recall shortly, of course, in commenting what has been excellently exposed by Dr. Uniyal, that when we discuss law, and India is a chief country in this sense, we discuss also rules, moral rules, or customary rules that become from our heritage and that silently, in a form unexpected, enter in our life. So there are two levels of law that I wish to focus in a theoretical and more generical talk having with you now. This is how we enter in the rules that are something that is being given to us. We do not choose what kind of rules must follow we have to follow in the course of our life. We normally are given these rules, and we receive them by many forms. So even in the younger age, we are accustomed to follow them, and of course we do not have any investigation concerning their roots. Okay, and what is more important, by which I wish focus the concept of law to be taught, it is how we construct the concept that we derive, how we construct education, how we construct the relationship that is linked from to our parents, to our family, to our stronger or lighter community, the closer one or the outer one. in what sense we select our rules, because there is something that it is undeniable, and I experienced this from long times, and because when we teach law, when we teach rules to people, when we teach how the legal system work, we teach something that is not only connected to us now in this moment, but in some sense it is something that has to be taught in the sense of make them able to focus the rules, to focus all the origin of the rules, where do they come from, where they are going to, because everybody of us, we are part of a developing system. We are part of the developing order, and we can experience these when we discuss even the more traditional form of, let's say, legal society, like family, for example. In West, we discuss every day since a long time how we have to redefine the concept of family, how we have to redefine the concept of parenthood. And if this penetrate also in this very closer system and very ancient tradition, it is very important to have a political subject, political in the sense of the member of a member of a citizenship, a member of a society, that are able to manage their own system, moral system, inside the larger system, in the progress of the world and the progress of the world in where they live. Okay, this is why I appreciate very much the relationship that I just heard, and thank you very much once again for this invitation to a very stimulating conversation with you, ladies and gentlemen. Thank you.
Professor Salvatore, Dr. Uniyal, thank you.
Now, so my wishes to everybody here, and Dr. Salvatore, Dr. Dilip, and others. It was a pleasure listening to all of you, and I tried to learn a lot. And I think very rightly said by Dr. Salvatore that at the bottom of the democratic relationships, how the laws relate to each and individual. When the society is the way changing, the nature of society is the parenthood, the relationships. I think the laws also have to change accordingly. Thank you very much.
So wait, just let me just capture a pic. So our next honorable chief guest, Sanjula, Dr. Sanjula, you have to hold on, stay there, please. Dr. Dilip Nandekoelyar, please, I invite you to address us with your enlightening views.
Thank you, Dr. Jayashree, and thank you to BNU. Nice to hear from Professor Salvatore and Dr. Uniyal. I have been following him. Again, I am not from the field of law. I'm from the field of business management, where I was resonating very well with Dr. Uniyal. I'll take a different thing from here, because I would say that law is the custodian of the ethical values of a society, and the society is evolving. This came to the fore when the United Nations adopted these 17 sustainability development goals. So each of those goals are, on the flip side, a liability which the society is carrying as a whole. Okay. Now the problem here is, while like Dr. Uniyal said, or for that matter, somebody from my home state, Dr. Thakur, I also come from Bihar. It was so heartening to hear from him. But in the complication of saying that this was the precedence and this is the test and that is the test, one starts getting scared. Maybe I have one of the a few things to say which is not very complimentary, but maybe just for the sake of laugh. There are 4 or 5 Was he speaking?
No, sir. You have to.
No, I just got a message from you. So there are 4 or 5 professions which I kind of equate to, they spring out of fear. Fear of the unknown. I wouldn't say that they are really genuinely creating that, but that's what it is. And to begin with, the first profession is that of an astrologer, who would say Rahu, Ketu, and something, something, and then you say what, and you start wearing all sorts of rings, all sorts of whatever, whatever. The next profession is that of a doctor. The moment he scares you, you don't know anything and you're so scared. The third profession is that of a lawyer, who can even scare you, okay, because you can just go behind bar and no law-abiding citizens. I believe that all of us are law-abiding citizens. We are scared, and then we do anything that we are asked to. The fourth one is that of a chartered accountant or income tax consultant, because again, that involves a punishment. Okay. And those 4 professions are quite similar in nature, only because there is no way we can understand the complexities of it. And I will agree with Dr. Uniyal that there must be some method to simplify this. For a common man, I count myself as one of them, to understand, not simply by literacy, but by somehow bringing it into a way of life. So there are these days, World Lawyer Day, World this day, World that day. We need to have this every month, where some aspect is debated publicly. What could be a liability to the society first? The law only comes after that. The law follows. Now, coming to the corporate, Dr. Thanvi, Ms. Thanvi talked about, many of the corporates have erred, but not deliberately. And they have. Take this Bhopal gas. We do not know if it was only the negligence or it was something that we were not aware of. I am still not, because I've been to Bhopal quite a few times before that and after that, and one just doesn't know. The fact is that the tragedy happened, and it happened. So therefore, I would say that law now would need to look at those 17 SDGs set and spin itself around it. Fortunately, if we talk about the Generation Z or Generation Z, then they have become very, very sensitive, and they have become very, very demanding. This means that product liability of any kind, or any kind of liability of any kind to the society, they will not take very kindly to it. And the best part is that they are powerful, and they are strong, and they can hit back. So it's not always in the court of law things can get decided. It can be also decided socially. And that's what they are doing anywhere in the world. Sometimes on the street, sometimes not very nicely. But the fact is that that is the fifth force, where fear is the key. I would like law to not make us afraid. Abiding because we are afraid, because there is a punishment, is not a very good way to live. I don't think that is. And to that extent, that is the liability that law carries. So I don't know whether I've made sense or not, but hearing all these kind of things, like what Dr. Thakur said, or what Ms. Thanvi said, or before that, I forget the name of the speaker, said, it scared me. It scared me. I mean, doctors can do that. Scared me. But then if I were a doctor, many of the things, like he said, I wouldn't do, but if it happens, it still scares me. So that scare part should go out of law. Law should be treated as friend. And how can you, all the luminaries who are experts in law, how can you make that friendly for a common man is the liability that law carries itself first. With that, I think we have already overstepped your time, and I know Dr. Jayashree has been really, slogging it out for last 7 days. So I won't. But it was good. I came and joined this soon as I could reach home, just because I wanted to learn, and I learned a lot. So thank you once again, and thank you to all the listeners who are there. And Dr. Jayashree, particularly you for having chased me. Thank you so much, and thank you, Mr. Salvatore. Uh, I wish we could meet someday. Thank you very much.
So it's indeed a very, I think my voice is echoing.
No, it's quite clear.
Yeah. It's clear to you?
Yes.
Indeed, it's really a matter of gratitude that you spared your precious hours and you continually kept yourself in touch somehow so that I can connect you and invite you on this platform. Indeed, my colleagues and host university management members, faculty members would connect with you, because from tomorrow onwards or day after onwards, I will be dealing with a big group of students to train them for their placements. So naturally, now my next mission is to connect with lots and lots of students of BNU for their job placements, and I've been assigned this responsibility. So in that process, I will connect with you all, the management people also, and definitely we can have a webinar with them before 5th April, and then you can process your way to how to come offline and to visit Udaipur and meet personally. You have a tourist plan. As a tourist, you plan your visit. That would be wonderful.
Right now,
Where you are located currently? Are you in Pune or outside India?
no, I am located in a place called Karjat now since last August, working for Universal Business School, and I also hold that co-chancellorship of a university in UK. But the news is that by end April, I'll be going to Sydney to meet my daughter. She's just been blessed with a child, and I want to see my grandson. So, and I'll be gone for about 6 weeks. So, mid-June, I will be back. I don't have any plans for coming to Udaipur as of now. I have a lot of friends there. In my corporate avatar, I have visited Udaipur several times, and it's such a beautiful city.
So why don't you then, with your friends, organize a sort of a formal webinar with other faculty members of management of Mohanlal Sukhadia and Bhupal Nobles University and other universities. Pacific University is also doing wonderfully in management. I often go as an external examiner there in management studies.
So if I am invited, I will come. And just let me tell you,
First, nowadays what has happened, that there is a trend that they generally prefer nearby people, personnel or officers or executives, the working in management field, so that they can have less cost to bear of traveling and etc. for their guest. So I feel that first you connect with them through webinar.
That's all right. You can connect me. I will come over. I will join them.
Like Professor Salvatore, he's also from Oxford University and currently in Argentine. So what he has done, he has connected with me, and somehow I'm quite a self-propelled person. So I made some kind of one after the other programs for him, and he is continuously in touch with Bhupal Nobles University.
No, I have no problems. I mean, I told you.
Similarly,
yes.
you can follow up with management. I'll tell them about your interest, and but still you have to send me your idea in which field you would like to contribute. Because day before yesterday there was some Pranjal Kumar Fukan. He was from northeast side of India.
I know him.
Yeah, so he too is interested. So you can plan your own program and connect Bhupal Nobles University.
Anything on management? See, let me tell you, I'm teaching in Victoria University. Okay. I am, of course, Commonwealth University, I am there. And of course, here at Universal Business School, I'm the Director of Industry Research, which is actually sponsored research, and head of the Department for Marketing. So all that is going on, so that's not the issue. And
Another aspect that I would like to bring here, that most of the members of teaching staff, they do not prefer to be on hybrid mode, especially in India. They would negate it simply. But in coming times, we know already, all of us, that it's going to be into a digital pattern. So it's better that you try to bring out with certain kind of plans. You can give to me. I will create a platform, because I know my faculty of management would not come forward. Even for Pranjal Kumar, they did not come forward. I am only inviting him one after the other. And they appreciate, because they want somebody to work digitally, and they all appreciate. They are enjoying that kind of, whatever glamour that I'm providing to them. But point is that you have to provide me with certain kind of plan, so that
So I'll tell you one thing. I have been following a lot of reports, and the way the world is moving forward. The important thing now is, like, since you're talking about placement and all, the important thing is to sensitize students that placement is not going to be same as what we think. Okay. In fact, World Economic Forum says that about 40% of the jobs as we see them now will disappear. So even if you get them placed, 5 years down the line, they might be, if they don't upskill. So the idea is to get into what is known as gig working. If you want a session on
this point, you give me a plan, that how can see, you have that concept. Now you have to develop one after the other this action plan, steps, to make it pragmatic.
I can conduct a webinar first to start with.
Yes.
If you see that there is interest amongst the students, then we can get into the nitty-gritties. Okay, I can conduct for your university. That's not a problem.
You send me an email as soon as possible, because then universities will get closed by 30th April, because our exams are going on all across India in post-graduation, graduation. That's why we have got so thin attendance in all webinars, because all faculty, everybody is engaged. Only I'm on leave to finish with the Salvatore's kind of a dream or plan. Otherwise, everybody is engaged right now in university exams. So
fine. In fact, just 3 days ago, I was addressing Dhaka Chamber of Commerce on this issue of how Southeast Asia, particularly Bangladesh and India, may have to reorient their youth towards thinking gig working and entrepreneurship. So fine, I mean, I'll send you, but the long and short is, we need to now look at gig working. In fact, lawyers are what? They are really gig workers, so
yes,
it's not a very new concept, but now it is coming into the traditional industry as well. So that's the thing.
Surely, sir. Right. You send me an email. Please keep connected to us. I'll follow up your program. Okay?
Yeah.
Thank you, sir. Thank you.
Okay. Thank you.
Dr. Salvatore, sir, please join in. Thank you, Deepa, for keeping connected to us. There's Dr. Ram Sharnagat Thakur and Dr. Sujala Thanvi. Professor Salvatore, sir, they have been our speakers of today. Please do convey some inputs. Sharnagat Thakur is a chemist and pharmacist, and Dr. Sanjula is a lawyer, advocate. He talked about criminal liability, corporate.
It's up to me, madam.
Namaskar, sir.
She wants to talk to you.
Okay, thank you.
Namaskar, sir. I am from Rajasthan University. I am associate professor at University of Rajasthan in law department.
Nice to meet you, dear professor.
Thank you, sir. I also want, I have heard the communication between you and Jayashree ma'am, and I also want to join this mission also.
It would be great. It would be great, doctor. We are arranging this institute about we already did actually about international private law. So
Right,
we
sir.
are to start working in few times, I suppose, and we are arranging first of all an international congress concerning pandemic in private law. So with very great pleasure, I hope that our common friend, Professor Singh, will put us in contact in order that we can start exchanging our information with great pleasure. Thank you.
Thank you, sir.
Good comment.
You are
Dr.
not.
Singh, Dr. Singh, you have mute microphone.
Yeah, the Professor
Okay.
Dr. Ram Sharnagat Thakur, he gave his lecture while traveling in train. So he's awaiting your inputs. Please do say something to him.
Sorry, I didn't hear precisely where I should.
He talked about
Okay.
medical profession and practices, and this what kind of securities, liabilities are there, as to keep in mind.
Yeah, doctor, you are a medicine man.
Yes.
Yes. We discussed the two very annoying position concerning
I
what
see.
is we suppose that is the main frontier, the main current frontier concerning medical liability and malpractice. That is a matter of omission in the harmful conduct of the medicine man. It is, it is a different range of articulation in legal field with respect to the commission something wrong and very simplifying this problem in the course of a profession. So the omission that is a very important source of liability in the course of the imputation of a medicine man in malpractices as a very special ether of demonstration of proofs of evidences and something like this. Notwithstanding, it covers the, let's say, the 50% of the current cases concerning malpractices. Not
Yes.
for what the medicine man has done, but for what the medicine man has not done and should have to be done.
Dr. Ramkumar, Dr. Sam, do you want to say something?
Okay. Thank you, and thanks for the nice words from Dr. Salvatore. The program was well conducted. All the eminent speakers, they have delivered their best to useful to all the participants, and from my topics, whatever the necessary elements
the basic elements of the liabilities and its consequences that I wanted to highlight. So to what extent it is useful to the participants that they can give feedback. So with this, but overall very well organized and arranged this program where topics are really very useful topics for society, and especially the advice given by Dr. Uniyal for making knowledge of law for common man easy and ways and means to be worked out for that. That's a very good suggestion. We need that each and every person, at least the basic elements of law is known to them. What are their rights, what are their liabilities, and how in the case of harassment and other things, what course of action they can take. So all those knowledge, basic knowledge should be there with each and every person. That's a very good social campaign for further extension of law door to door. So with those objectives, if things move forward, then definitely it will be very useful for the society at large, and all the practitioners, legal practitioners also, their importance also in the society, that will be well established. People will remain also protected from exploitation and all. So this is how, because law is misused to a great extent. At times it is very badly misused and real people are harassed. So in absence of knowledge, those things do happen rampantly. And if things are streamlined, people have proper knowledge about the basic knowledge, especially of the criminal law, civil law, and their rights, the constitutional rights of the people, infringement upon that, then the society will prosper in all aspects. That's all. Thank you. Thank you so much.
Thank you, Doctor. I think this one
Pardon?
attendant. Thank you, Doctor. Thank you.
Thanks. Thanks so much. So we can part now.
Yeah, you can go. You
Thank
lead because I think Professor Salvatore is going to discuss about further
Okay. So please
action
continue.
plan that is to be dealt after this symposium.
Okay. Thank you.
Deepa Rastogi, do you wish to say something?
Ma'am, it's really wonderful to listen you all, and it's very deep, analytical, intellectual conversation. Still, I feel privileged and blessed that you asked me to say a few words about that. I can respond if you ask me some questions or whatever I have understood throughout the whole webinar. All the delegates and speakers conversed a lot about various ideas and their own thinkings. So if you ask me about any particular one, then I can elaborate. Otherwise, I feel extremely contented and very curious to know more about that. In our daily life, we don't read so many books, and we don't have such environment so that we can learn like that. So I insist you, ma'am, to every time send me the link so that I can be a part of it, whether as an audience or a speaker. Again, I would like to say it's my privilege that you asked me to say something. Ma'am, I can't hear you. Something is. Yeah. Now I can hear you.
Deepika, we will send you feedback link tonight, and you can leave your comments there or any other further query, and we will get you back and connect to you.
Thank you. Thank you, ma'am.
See you. Right. You can leave, Deepa.
Okay, thank you. Have a great day ahead.
Yes,
Good
have a
night.
nice- Good night. Yes, sir.
Dear Professor,
The
we are
floor
the
is now.
we are the island. Only one will survive.
Yes, I'm the islander, but I know how to get hold of the treasure islands.
Yes, yes, yes.
The
Okay.
treasure island. It's a treasure island.
Yes. And we should go on with may I talk in this?
Yes.
Okay. Yeah,
Or
yeah.
shall I stop recording? Shall I stop
Yes.
recording?
Yes, stop recording because we are.
Wait. There's something wrong today with this tab.
Okay, we can continue. We can continue through our or WhatsApp system if you want.
Yes. Yes. Okay. Right.
Okay.
Right, sir.
Okay.
Bye. So connect later on after 5 minutes. If you
I will
wish.
connect. Sorry, where?
If you wish to connect, then connect through WhatsApp.
No,
Or
let's connect through WhatsApp. Okay.
yeah, I'm turning it or leaving now.
Thank you very much for this very 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 stimulating morning for me and the night for you. Okay. Thank you. Talk
And
to
if
you
you
through
wish
WhatsApp.
if you wish to connect, send me a message via
Okay.
WhatsApp.
I'm here. Bye bye.
Thank you, sir.
Bye. Bye.